Since the beginning of our republic, we lawyers have enjoyed a monopoly over the practice of law. We have controlled access to the law. We had the keys to the law library and to the courthouse. Anyone who had a legal problem, thank you, had to see a lawyer. There was no choice. We set the standards of admission to the practice. We restricted access to the bar. We controlled who could give legal advice. We decided what we needed to know and what the clients should know. We set the process and we made the rules, thousands and thousands of rules. We created the box. We didn't have to think outside of any box. The rules that govern our profession today are restricting our ability to practice law. More importantly, though, it's restricting customers, our clients' access to the law. Most of the rules that govern our profession today were promulgated in the 50s, in the 20th century, and even earlier than that. Let me show you. This was the mode of transportation and the mode of communication when licensing rules were first promulgated by the Florida legislature. When the Board of Law Examiners was formed, this was considered modern transportation and modern communication. When we restricted partnership with non-lawyers, when we restricted sharing fees with non-lawyers, this is how we went on airplanes, and that phone was the way we communicated. This was the modern form of communication when UPL rules were first adopted, and that was a modern phone. The old guy here has got a cell phone, and he thought he was the big man on campus because that's how he communicated, and that was the new form of communication. This is how we communicate now. This guy. We all live this way. Yet, our rules were promulgated at a time when nothing that you see in this picture existed, when we didn't live or work any way, shape, or form like what it looks in this picture. We are stuck in the past in the face of the future. And, as you will see, I like this picture, we lawyers are too busy to change. We don't want new technology. We think we have it right. And we really don't. The keys to the law library are no longer ours. They are no longer ours. We no longer have exclusive control of the law. Technology has made the tools of our trade affordable and accessible to everyone, including our clients. Our customers, the consumers of the law, now have online access to legal forms and to case law. Technology provides the consumer with a frictionless experience in the law. Let me show you an example of what I mean. Simple, easy, fast, and friendly. We have to accept that we are no longer a monopoly. We have to accept that we are now part of a legal marketplace. We have to welcome others into our marketplace. We have to work with, not against, businesses who give people, our customers, our clients, accessible and affordable and convenient solutions to their legal problems. In order for us to take advantage of the boundless opportunities, and we do have boundless opportunities, we have to change, and we have to do so quickly. The problem that we face as your bar leaders is the scope, the breadth, and the speed of change. This is an amazing time to be a lawyer. Everything about our world is changing, even the words we use. Legal research is now knowledge management. Computers, search engines, analytics, and algorithms have replaced shepherds, advance sheets, and the digest. We mine for data using e-discovery tools. Lawyers are less and less involved in the manual labor of our work. We don't use books anymore. We have computers create our documents, maintain our calendars, bill our time. We store our documents in the cloud. You see, technology, if you think about it, really gives us the opportunity to actually practice our craft, to give advice to our customers. Technology gives us unlimited, immediate access to information. Technology makes it possible for us to work from anywhere, for anyone, at any time. And that's good for us, and it's good for the consumer. Technology gives us unlimited, unprecedented, and unbelievable opportunities to do what we love to do, practice law, and still make an affordable living. Just a few years ago, I was like many of other lawyers. I had no idea. I was completely unaware of the rapid change going on in our profession. Over the last year, Greg and Jack and I have attended many meetings and conferences where we talked to the thought leaders, and we learned that the innovators were talking about the relentless pace of change. This is now the picture of Greg at most of the conferences, because he too was stunned, as was I. The most amazing part of this journey was you sit with Jack Harkness. Jack is iconic in the world of bar leadership. And when you sit with Jack, and you lean over and you go, Jack, you ever see anything like this? And Jack has seen it all. And he whispers back, no, I've never seen anything like this. I don't know how this is going on so fast. And then you listen and you go, it is happening. Jack is excited about our change. Jack understands that to preserve our profession, we need to change. Our bar executive staff, they're their names and their years of service. They are wonderful, experienced, solid, experts in the field of advertising, UPL, all the issues that we're confronting. They're excited as they see us moving into a new paradigm. Vision 2016, Greg talked about it. They're also engaged in the analysis of the change of the practice. Perhaps the most important work they're performing is confirming that everything's changing, and understanding that everything will change, and making recommendations for the change. Imagine getting lawyers to think different, like Gordon wants us to do. Imagine that. Imagine if lawyers could work more closely with legal innovators who already provide accessible, convenient, cost-effective legal services for clients, and make our practices more profitable, while still maintaining the core principles of professionalism. Every one of these companies, everyone on that screen, we've spoken to their CEO, and not surprisingly, they want to work with the regulated bar. They want to be regulated. They understand our core principles of ethics and professionalism. Imagine if Florida lawyers could work with a client in any state. We can't at the moment. Imagine if the bar rules of reciprocity in the uniform bar exam were changed. Florida lawyers could work there, anywhere, at any time, in any place. We should consider changing to a uniform bar exam, and dropping restrictions on reciprocity. Imagine if law schools could develop course curricula to prepare every law student to practice law. We could work more closely with the deans to fix what is already known to be a broken system and change the mode of education to accommodate an academic and a practical experience. We could decrease the number of tests on the bar exam so that law schools could teach more practical courses to students instead of teaching to the test, the bar exam. We could encourage the ABA to remove arcane and obsolete restrictions on law schools as to what they could teach. Imagine if lawyers could more easily work with technology and paraprofessionals to improve the services we provide our clients, serve more customers, imagine that, and perhaps help solve the access to justice problem. We have not done it alone, and we can't. By creating new types of paraprofessionals like already exist in Washington State called limited liability legal technicians, or some other form of non-lawyer service provider, we could expand the people that assist the citizens of the state of Florida who can't, don't know, or can't afford lawyers. By using new tools and technologies, we could expand limited scope representation. It's called unbundling. It's a great business opportunity for us. Imagine if all lawyers were competent in the tools of technology. Imagine that. If we required lawyers in Florida to take more technology, we could go from looking like that first guy to looking like this guy. By encouraging lawyers to take more CLE, we can actually become more efficient, more effective, and more accessible. Imagine now if you could predict how a judge will likely rule on any issue. Imagine that. Watch this.
Ravel is driven by a belief that by applying precise, powerful technology to legal research, we can help attorneys find case-winning insights. Judge Analytics was conceived and developed to help you understand how a judge thinks, writes, and rules. To understand your judge, you can use Ravel to spot patterns and highlight outliers about how your judge reasons and writes, as well as which cases, judges, and jurisdictions she finds most influential and persuasive. Drill down to see issue-specific details and discover the arguments your judge favors, as well as the cases and language she commonly cites. Seamlessly pinpoint individual distinctions you need to know about. You can uncover revealing insights that were previously hidden amidst millions of documents and data points. The trends and tendencies of your judge that firm-wide emails and anecdotes don't unearth. This is a new era of data-driven lawyering. Welcome.
You don't have to imagine. That's the reality. And that is the product of lawyers, law students at Stanford University partnering with the computer science department at Stanford and the school design, partnering to reimagine legal research. And there it is. Imagine if we made it easier for lawyers to be trusted advisors and counselors. When I started practicing law, my card said attorney and counselor. And all of our cards lost the counseling part and we all became attorneys. I think we need to go back to being counselors. We could do that if we released the restrictive shackles of our rules. If we could provide more affordable, accessible, and convenient legal services, we'd still make a good living. By using technology to perform the tasks that distract us, really, from our true role as counselor, we could help our clients. We could reinforce the foundation of ethical and professional behavior that makes us lawyers different from everybody else in the marketplace. That's what we have. There are going to be a lot of new people and new businesses in our marketplace, and some of them will be really good, and some of them won't. But none of them will have our training, our ethical rules, our commitment to helping and serving clients based on our rigid ethical foundations. That will distinguish us in the new marketplace. So you see, folks, instead of fearing technology, if you look at it, I think it's a gift. We don't have to do menial tasks anymore. We can focus on solving interesting problems. We can solve complex problems. We can have others do the things we really shouldn't be doing anyway and serving our clients. By embracing technology, if you think about it, our overhead costs will fall. We could work like this guy. We will have new flexibility in the hours that we work. We will have new flexibility where we work from. Military and corporate spouses won't have to take a bar exam every time they move somewhere else. But see, lawyers, I think we're the problem. We're skeptical, we're cynical, we're deliberative, adversarial, autonomous thinkers, trained to be analytical all the time. We have to get it right. We need to get it right because we are ethically bound to do so. But you see, and that's our job as lawyers. When it comes to the future of our profession, though, we can't think like that. We have to come up with a new way of thinking. We have to look at opportunities. We have to look outside the box. We need to be prepared to face the new reality so we minimize the risks. But first we have to understand them. And so we can maximize the benefits. It's a great time to be a lawyer. It really, really is. And right now, if we pay attention, we still have a say in where we fit in the marketplace. We can control how, when, and where we provide service to our clients. We need to embrace change. We cannot resist it, and we shouldn't resist it. So where do we go from here? Since I became president-elect, people have been asking me, what's your plan? What are you going to do? What are you going to accomplish? I didn't think it was right to answer it. It wasn't my time. It was his turn. It wasn't my place. And I really don't have a plan. My plan is that we are going to accomplish anything. We will work together to change the bar. There's an old saying that says, if you want to go fast, go alone. If you want to go far and do big things, you need to go together. So we are going to turn the aircraft carrier of the Bar Association and the bar on a dime. And we're going to do it together. And you see, it can really be done if you just put your hand on the wheel and spin it. We are going to lead the bar into the 21st century. The young lawyers, with the leadership of Gordon, who's wonderful, the Supreme Court, the Florida Board of Bar Examiners, the law deans, the Florida Bar Foundation, we are going to make a better life for ourselves. We can go far. We can meet the new reality. We can have better lives. We can achieve a better work-life balance. We can spend more time with our families. We can do that. And see, most importantly, and sometimes we lawyers forget that, if we work together, we can ensure liberty and justice for all. Thank you very much.